major assets of a marriage. The two major assets of a marriage are normally the family residence and the pensions. The new reality. In the past, when real estate values were always rising and most houses had equity, divorcing spouses would sell the real estate and use the net proceeds to purchase their own residence in the neighborhood. Since the housing market is still feeling the effects of the recession, the question is what to do with the family residence. Depending on the mortgage amount and where the residence is located, the residence may be underwater or may have little to no equity after sales costs are taken into account. The new reality is that divorcing spouses need to consider the following. First, what is the equity in the residence before selling? 2, what is the equity in the residence after sales costs? 3, what are the mortgage, taxes, and insurance payments on the family residence versus the cost of simply renting an equivalent house? And last, how important is it to keep the children in the same school district? This new reality means the divorcing spouses need to look at all the options available in disposing of the family residence. Options in the disposing of the family residence. Some options when disposing of the family residence are as follows. 1, sale. 2, buyout. 3, short sale. 4, foreclosure. 5, deferred sale, rent to a third party. 6, deferred sale with spouse and children in residence. Remember, each option should be reviewed carefully. No matter what option is selected, the parties should memorialize the agreement in a marital settlement agreement, also known as an MSA, to take into consideration all the issues that each option triggers. Option 1, sale. Issues raised by a sale. Selection of a joint broker or agent. Determination of price. Parties' refusal to sign required documents. Efforts to prepare the house for sale. Division of proceeds, such as taking into account reimbursement of separate property down payment, if applicable. The parties' written agreement should include provisions allowing the family court to make a decision regarding the sale when the parties later cannot agree on the following: the selection of a broker or agent, the sales price, and the appointment of a clerk called an advisor to sign on behalf of a non-cooperative spouse. Option 2, buyout. Issues raised by a buyout. Appraisal and buyout of the other spouse's half of the community property equity in the residence. Note under existing law, the purchaser gets the original tax basis and the purchaser does not get a reduction for later taxes upon sale or cost of sales commission. Option 3, short sale. Issues raised by a short sale. Selection of a joint broker agent. Effect on credit ratings. Like in a sale, the parties' agreement should include provisions allowing the family law court to make decisions regarding the short sale when the parties later cannot agree. Include language in the agreement that allows either party to seek an emergency hearing before a family law judge to break the deadlock. Option 4, foreclosure. Under certain circumstances, the parties can or may want to allow the family residence to go into foreclosure. If this occurs, the parties may want to stop paying the mortgage on the family residence while the foreclosure process takes place. Issues raised in a foreclosure. Determination of the mortgage-free benefits to the spouse living in the residence and the effect on support. And last, the effect on credit scores of both parties. Option 5, deferred sale and rent to third party. There are 7 issues raised when divorcing spouses agree to hold the family residence as a joint investment property until the real estate market improves. First, title. Parties remain tenants in common on the property title. 2, loan. Conventional loan. Both parties are on the loan and remain liable for the payments. Parties normally cannot purchase a new home without disposing of this family residence. 3, landlord-tenant issues. Determination of the responsible party for maintenance and allocation of maintenance cost. 4. Mortgage payment. Allocation of mortgage interest on taxes. Allocation of negative cash flow, if applicable. 5. Tax payment. Allocation of property taxes paid on the family residence. 6. Taxes on the net proceeds of the sale of the residence. The timing of the sale may be dependent on when the parties qualify for the exclusion of the gain on the sale of the residence. IRC Code 121 requires that the residence be the primary residence of the seller for 2 of the last 5 years. This is a complex area, and you should seek the advice of a good accountant. Number 7, when to sell. The parties must clearly agree upon the triggering events for the sale of the residence. Option 6, deferred sale with spouse and/or children staying in the residence. A deferred sale while one party remains in the residence raises the following issues. 1. Title. Parties stay tenants in common. 2. Loan. Conventional loan. Both parties are on the loan and remain liable for payments. The spouse not residing in the residence normally cannot purchase a new home without disposing of the family residence. 3. Landlord-tenant issues. Basically, the in-spouse is renting the family residence. Determination of the responsible party for maintenance. Allocation of maintenance costs. 4. Rent and mortgage payments. Is fair rent going to be charged? If not, how is the spouse not residing in the residence going to be compensated? Allocation of mortgage interest on taxes. Allocation of negative cash flow, if applicable. 5. Property tax. The allocation of the property tax on the family residence. Tax issues. If the residence is not the primary residence 2 out of the last 5 years. 6. When to sell. What are the triggering events for the sale of the residence? All the possible problems and contingencies that any of these options could trigger should be considered and the agreed upon resolution written up in the marital settlement agreement. The takeaways. The new reality in real estate is that divorcing spouses need to look at all the options in disposing of the family residence. Each option has pros and cons that need to be analyzed carefully. The agreement and all the contingencies reached between the parties should be included in the marital settlement agreement.